Okay, let's unpack this.
Welcome to the deep dive. Today, we're really getting into the core of how ancient societies were structured. We're looking at status, power.
Right, the foundations. We're trying to figure out how people in ancient Rome and Greece decided who was in, who was out, who held the power.
Exactly. We've got sources covering Roman law, family, property, all the foundational stuff, and then Greek history, the big political clashes, the rise and fall of city-states.
And we're aiming to understand that sort of source code behind it all. How did legal status actually shape someone's life back then?
And, for you listening, understanding these concepts is really key because these ideas about belonging, about authority, about even things like shame and debt, they cast long shadows. They reveal the kind of invisible constraints that shaped law and politics then and maybe still resonate a bit today.
It's fascinating how central community and relationships were, right? Not just the individual. So let's start right there at the beginning. The foundations of status. Kinship, community, authority.
Well, yeah, if you look at the really early commonwealths, the thinking was incredibly rigid. Basically, kinship being related by blood was seen as the only possible basis for political community.
So if you weren't family, you weren't really part of the political game.
Pretty much. It's like tribal logic scaled up. Your political identity came directly from your lineage.
Okay, that makes sense for a small, tight-knit group. But what happens when you get a big, bustling city like Athens? Lots of people, newcomers. That blood tie model must have started to creak a bit.
Oh, absolutely. It became a major constraint. And the shift away from it, our sources call it a revolution of feeling, which tells you something, right? It wasn't just changing a rule.
A revolution of feeling, so deeper than just politics.
Definitely. It fundamentally changed how people saw themselves and their neighbors. The old power structures, the aristocratic families linked by blood, they started to lose their grip when the basis for political action shifted to local contiguity, basically where you lived.
So like in Athens with Cleisthenes and his reforms, when he set up the demes based on geography.
Exactly that. It sounds maybe bureaucratic now, just drawing lines on a map, but it was radical then. He essentially broke that ancient assumption that you needed shared ancestry to participate fully in the city's life.
So people living next door, maybe from totally different clans, suddenly had to work together politically, vote together, fight together.
Right. It redefined belonging. It wasn't just about your genes anymore. It was about your shared space, your neighborhood becoming your political unit. A huge mental shift.
Okay, let's hop over to Rome then. Their structure seems just as layered, but maybe organized differently. I like that image of concentric circles.
That's a great way to visualize it, yeah. Because everything flows from the center outwards. The absolute base unit is the family, and that's defined purely by everyone being subject to the highest male ascendant.
The paterfamilias.
The paterfamilias. Then you group families together and you get the gens or the house. Group houses, you get the tribe. Group tribes, you get the commonwealth, the state itself. The individual. Well, they only really mattered in terms of where they fit in those layers.
And at the very heart of it all is that figure, the paterfamilias. His power, the potestas, sounds almost mythical.
It was immense.
Yeah.
Sweeping authority over the entire household. Children, grandchildren, slaves, property, everything fell under his potestas.
And this ties directly into inheritance, right? Especially with the will, which seems like such a critical document for Romans.
Absolutely critical. The Roman last will and testament. Well, dying without one, dying intestate, was seen as a major social failure, a disgrace for any family of standing.
A failure of the paterfamilias.
Yes, a failure in his final duty, really. The duty to impose order, ensure the family name and property of the familia continued properly, honorably. The will was his last act of command.
So within that framework, what about the heirs themselves, the ones directly under his power, the suiterities? You mentioned their position was unique.
It was. The suiterities think a son or daughter still under the father's potestas. When he died, they were considered, in a way, owners, even while he was alive.
Owners? How could they be owners if he had total control?
It's subtle. The idea was they were already part of the enduring ownership of the household property. His death didn't give them ownership, it just removed his overriding authority, his potestas, that sat on top of their inherent right. It was like a release, not a transfer.
So legally they had this underlying right, but practically they couldn't do much with it while he lived.
Pretty much. They were subordinate, major legal acts, needed his say-so. It really underscores his total command.
And this leads to that, well, frankly, chilling legal logic you mentioned earlier.
Yeah, this is where the sheer weight of the potestas becomes starkly clear. The Roman jurists were quite blunt about it. They noted that the reason a father had the legal right to formally disinherit his suitors in his will
To cut them off completely from the family well?
was because he also held the ultimate legal authority to kill them.
Wow. The power over property was justified by the power over life itself.
It's a profound connection. It makes disinheritance not just about money, but a fundamental severing, almost like a social death sentence, handed down in that final, powerful document, the will. It was the ultimate expression of his lifelong potestas.
That focus on the will as the final command and this deep fear of social disgrace, it sets us up perfectly for the next layer, doesn't it? The social ladder, especially how inheritance could be used strategically.
Right. Here's where it gets really interesting. Because this obsession with reputation, with avoiding the shame of, say, insolvency, led to some very creative, maybe even cynical, legal tools.
You mean like the slave heir, the necessarius here?
Exactly. The inevitable heir. It sounds counterintuitive, doesn't it? A Roman elite, obsessed with lineage, making a slave the centerpiece of his inheritance plan.
Why on earth would they do that?
It was basically reputation laundering, Roman style. The necessarius heirs was a slave named as heir in the will, usually bundled with the promise of freedom. The crucial part, why they were inevitable, is they became free, and the heir automatically, when the testator died, they couldn't refuse it.
They have no choice. So freedom comes, but maybe with a massive catch.
A massive catch. The main reason for doing this was if the testator suspected he was insolvent, if his debts were bigger than his assets. By naming a slave as the necessarius heirs, the messy business of selling off the estate to pay creditors.
The bankruptcy sale, the vindictio bonorum.
Exactly. That whole public spectacle of failure was carried out in the name of the newly freed slave heir.
Unbelievable. So the dead paterfamilias and his actual family were shielded from the public disgrace. The bankruptcy stain fell on the former slaves.
Precisely. It's a stark example of how law could be used to transfer shame. Roman elites prized their dignities, their honor, enormously. Financial ruin was social death. This mechanism legally shifted the identity of the bankrupt estate onto the freedman, keeping the testator's name clean.
That's an incredibly heavy burden for someone's first taste of freedom. Was there any kind of legal protection or compensation for taking that hit?
There was, yes. The system wasn't completely ruthless. The slave heir, now a freedman, was allowed to keep anything they acquired after the patron's death. This was called the quid sibi acquisiat. And crucially, the law put up a firewall. This personal property couldn't be seized to pay off the patron's old debts.
So his future earnings were safe, even if his name was initially linked to the bankruptcy.
Right. It gave him a chance to build a new life, even though he'd served as the financial scapegoat for his former master's failed estate. It's a complex mix of exploitation and pragmatic protection.
Okay, moving from that specific, rather grim scenario, what about the more general path to freedom manumission? You said initially it was often just de facto.
Yeah, meaning it wasn't always formally registered. A master might just stop treating someone as a slave, let them live independently, but that was precarious. Legally, the master could change his mind, reclaim them. There was no state guarantee.
So for real, secure freedom, you needed the community, the state, to recognize it officially.
Exactly. You needed a formal process to bind the master and make the freedom permanent. Roman law developed three main ways for this.
Which were?
First, in the will by testament. The master declares the slave free in that crucial document. Second, vindicta, which was a sort of staged legal action before a magistrate where freedom was formally asserted and granted. And third, by census, having the master allow the slave's name to be put on the official citizen rolls during the census.
And getting freedom through one of these formal routes, did that make them a full citizen instantly? Same rights as someone born free?
Not quite, especially initially. The freed person, the libertus or the liberta, was personally free, yes. But they still owed duties and respect obsequium to their former master, their patron. They were seen as clients. Over time, they generally gained the status of plebeians, but full political rights like a freeborn burgess. That often remained limited, reflecting that ongoing client relationship.
And it sounds like freed women faced even more constraints.
They did. Roman women generally needed a guardian, a tutor, for certain legal acts anyway. But for a freed woman, her situation was particularly tied to her patron's family line. If her patron died, and there were no direct male heirs left in his family, maybe he had no sons, or his son got adopted into another family.
Breaking that male lineage.
Right. In that specific case, she actually had to apply to the state under laws like the Lex Atelia or Lex Iulia Aetia to get a new tutor appointed.
So even after freedom, her legal capacity, her ability to act independently in law, was still fundamentally linked to the continuity of her former master's male line.
It really highlights how Roman law was built on these intricate webs of dependence and authority, far more than on abstract individual rights as we might think of them today. Gender, status, family line, they were all deeply interwoven.
Okay, let's scale up from the family and the individual will to the level of the state itself. We're moving into the architecture of law and sovereignty, and here Rome seems to have used legal concept quite powerfully, particularly this idea of maestas.
Maestas is fascinating. It literally means greaterness or majesty. But the key insight from the sources is that it's an unusual abstraction because it comes from a comparative word, greater.
And why is that comparative aspect so important legally and politically?
Because greater implies a hierarchy. If Rome possesses maestas, greaterness, then logically all other states must possess. Well, lesserness. You can't have two entities both being greater in the same relationship. Only one can hold that supreme maestas.
Which means, in Roman eyes, only Rome was truly sovereign.
That's the stark political implication, yes. Roman theory essentially positioned Rome as the only genuinely sovereign state in the world. Everyone else was, by definition, secondary, subordinate in dignity.
That's quite a legal basis for, well, imperialism, isn't it?
Absolutely, it provided a powerful justification. If another state failed to acknowledge Rome's superiority or comply with its demands, Rome could frame that not just as disagreement, but as an offense against its inherent maestas, its rightful greaterness. It could legitimize intervention, even conquest.
And the strong sense of hierarchy, did it also shape Rome's internal legal system? The courts, for instance. It wasn't just one single court system, was it?
No, it was quite complex, especially for criminal law. You had the statutory questions, these standing courts set up by law to handle specific crimes like extortion or murder. Then you had the Senate, which often took on big political cases or crimes involving the elite, things like forgery or maybe homicide among senators.
And the emperor?
And increasingly, the emperor's court, often operating through his key officials, became a major judicial force.
Like the urban prefect, often just seen as Rome's police chief, but his role sounds bigger than that.
Much bigger. The urban prefect wasn't just patrolling the streets. He had significant judicial power, handling serious cases, including capital crimes that happened within Rome and even quite a distance outside the city. His jurisdiction, in terms of the types of cases, was actually comparable to a provincial governor's.
Though presumably dealing with a different cross-section of society.
Oh, certainly. While he could judge local gentry, the vast majority of people brought before the urban prefect were likely from the lower classes, plebeians, or slaves. It reflects that stratified justice system. Serious crimes involving ordinary folk often got handled swiftly and decisively by this high official.
And sitting above all these courts ultimately was the emperor himself. Wasn't he able to intervene directly?
Yes, the emperor held the ultimate trump card. He could exercise this extraordinary power called restitutio in integrum,
Which means?
literally restoration to the original condition. It meant reinstating someone who had been condemned, reversing the sentence, restoring their legal status. It was a massive power, fundamentally overriding the original court's decision.
And provincial governors couldn't just decide to do this themselves.
No. The sources show that by the time of Marcus Aurelius and Lucius Veracus, the Divi Fratres, indicating that increasing imperial centralization, governors were explicitly told they had to refer any request for restitutio back to the emperor.
So even the judge who passed the sentence couldn't undo it with restitutio. Only the emperor.
Exactly. It's a clear message. Ultimate justice flowed from the top, reinforcing the emperor as the embodiment of Rome's unique maestas.
Okay, let's shift gears slightly from criminal justice to civil contracts. Roman law had this reputation for being incredibly formal, especially with the verbal contract, the stipulatio.
Oh, absolutely. It was all about precision. With stipulatio, the contract's validity depended entirely on the exact words used. The question and answer had to match perfectly in form.
Can you give an example?
Sure. If I asked, "Do you promise spondesne to give 10,000 sesterces?" and you replied, "I promise spondeo," using the same verb, then bam, valid contract under the old civil law. But if you replied with different wording, maybe, "I will certainly pay," or used a different verb, the obligation might just vanish, legally void.
That sounds incredibly rigid. How did they manage that in a huge empire dealing with lots of non-citizens who wouldn't know these precise formulas?
Well, that's where Roman legal genius kicked in. They used legal fictions, basically ways of bending the rules without breaking them. They'd use analogy or this thing called the contrafactual imperative.
Meaning they Just pretend something was true for legal purposes?
Pretty much. So strict civil law procedures might only apply to citizens, but trade needs to happen with non-citizens, Peregrini. So the praetor, the magistrate who shaped legal practice, might issue instructions for a case involving an alien. He'd tell the judge, essentially, proceed as if this foreigner were a Roman citizen.
So the judge applies the citizen law not because the person is a citizen, but because the formula tells him to act like he is.
Exactly. It allowed them to bring aliens into the legal system, ensure contracts could be enforced, keep commerce flowing, all without formally rewriting the sacred ancient civil law itself. They kept the formal structure intact, but achieved practical flexibility. It's quite brilliant, really.
So we have Rome with this incredibly developed, adaptable, yet status-obsessed legal system designed for control and stability. Let's contrast that now with the Greek world. The sources here seem to highlight moments of, well, spectacular failure and political drama when rules of obedience or status break down.
Yes, the Greek examples provide a really sharp contrast. We see the immediate, often brutal consequences of miscalculation, ambition, and the failure of civic virtue, both on the battlefield and in politics.
Let's start with that story about the Argives and the Spartan king Cleomenes, a military disaster rooted in predictability.
It's a classic tale of how predictability can be weaponized. The Argives knew the Spartans were creatures of habit, very precise with their military commands. So the Argives decided their best tactic was just to listen for the Spartan herald's commands and mirror them exactly.
Thinking they could anticipate every move.
Right. But Cleomenes figured out their plan. He gave his own troops secret orders. When the Spartan herald inevitably gave the standard loud command for the dinner break,
Which the Argives would dutifully follow.
Cleomenes' men had been told, ignore that command, stay ready, and attack the moment the Argives relaxed for dinner.
Ouch.
Ouch indeed. The Spartans fell on the Argives while they were literally eating. It was a complete rout, a massacre so bad, the sources say it crippled Argos' power for a generation, a fatal lesson in not substituting mimicry for actual strategic thinking.
And Cleomenes himself, despite that cunning victory, his own story ends quite differently, doesn't it? Showing the constraints even on a Spartan king.
His downfall is really telling about the Spartan system. He was locked in this bitter rivalry with his co-king, Demaratus. Cleomenes went to extraordinary lengths to destroy him. He even bribed the priestess at the Oracle of Delphi
The most sacred site.
to deliver a fake prophecy saying Demaratus wasn't legitimately born, which led to Demaratus being deposed. Deep political corruption using religion itself.
But it backfired.
Eventually, yes. When the plot came out, Cleomenes had to flee Sparta. Now here's the twist. The Spartan authorities later decided, maybe for political expediency, to invite him back. But by then, according to the sources, something had snapped. He seemed genuinely mad, paranoid, possibly from the stress or guilt.
And this led to that gruesome end.
Tragically, yes. He became violent, had to be confined under guard. He somehow coerced his Halic guard into giving him a knife and then inflicted terrible wounds on himself, dying in this brutal, self-destructive way. The ancient writers saw it as a tragedy of a talented man ultimately broken by the very system he tried to manipulate. The checks and balances of the Spartan state, the co-king, the ephors, prevented him from acting decisively, perhaps driving him to extremes.
That Spartan caution, that internal checking, it really contrasts with what the sources describe as the Athenian imperial instinct, especially after the Persian Wars, right? After the victory at Mycale.
Oh, the difference is stark. After Mycale, a joint Greek victory, the Spartans and their Peloponnesian allies did the typical Spartan thing. Declared victory, packed up, and went home. Job done. Focus back on the Peloponnese.
At the Athenians?
The Athenians, along with the Ionians, led by Xanthippus, saw an opportunity. They didn't go home. They immediately sailed to the Hellespont and besieged the strategic fortress of Sestos, eventually capturing it.
And why is that moment seen as the birth of the Athenian Empire?
Because it revealed a fundamental difference in mindset. Sparta, cautious, defensive, regional. Athens, ambitious, outward-looking, seeing themselves as leaders of all Greeks, what the source calls a pan-Hellenic point of view. They had this impulse to project power, secure strategic locations. Taking Sestos was the first concrete step in turning that impulse into reality, leading directly to the Delian League and everything that followed. It was about defining status through active dominance, not just defense.
So different paths to power and status. Now let's look inside Athens. What about the pressure on the individual citizen? How did Athens ensure its citizens met their obligations, especially military ones?
Well, the core civic virtue was, Andrea, usually translated as manliness or courage, especially in battle. But interestingly, the emphasis seems to have been less on achieving heroic distinction and more on avoiding failure, specifically cowardice.
Not bringing shame on the community.
Exactly. Think of the famous ephebic oath young Athenian men swore. I will not disgrace my sacred arms, nor will I desert the man next to me. It's about reliability, holding the line, meeting the minimum standard was crucial.
And if a citizen failed, if they shirked military duty or other civic responsibilities, what happened then?
Athens had a powerful legal weapon, atemia, disenfranchisement, basically the loss of civic rights.
Which sounds devastating in a society like Athens.
It was social death, in many ways worse than a fine. It meant you couldn't speak in the assembly, couldn't serve on a jury, couldn't hold office. Often you couldn't even use the courts to sue or defend yourself.
And what triggered atemia?
Several things related to civic failure. Obvious ones were military cowardice or draft evasion, but also serious financial default, failing to pay debts owed to the state, like war taxes, or even just defying certain prohibitions like continuing to hang out in public spaces like the agora if you were officially listed as a state debtor. It was the city's way of saying, you failed in your basic duties. You are no longer a functioning part of this political community.
We've covered so much ground, from the Roman father's absolute power embodied in his will to the calculated risks of the slave heir, the meaning of Roman maestas, and then these Greek examples of ambition and failure. So, pulling it all together, what's the big takeaway here?
Well, I think this deep dive really shows that ancient law, whether Roman or Greek, wasn't primarily about abstract justice in our modern sense. It was much more fundamentally about creating and maintaining social structure. It is about defining very clearly who belonged, who had power, and crucially, how to manage the risks and conflicts, especially the social disgrace that inevitably arose from that power and status.
The systems seem designed to manage risk, don't they? Like the Roman will, using the necessarius here is to absorb the shame of bankruptcy.
Exactly. Protecting the family name, the lineage, was paramount. That mechanism legally transferred the disgrace away from the core family unit.
And Roman maestas gave them a framework to manage the risk of external threats by defining Rome as inherently superior, justifying preemptive action.
Right. And the emperor's power of restitutio was about managing the internal risk of judicial error or dissent by concentrating the ultimate power of reversal at the very top.
While in Greece, maybe the risk management was less about legal finesse and more about direct, sometimes brutal, consequences. Military failure like the Argives faced, or the social annihilation of atemia for the failed citizen.
Precisely. Different methods, but the same underlying concern with maintaining order and managing the fallout when things went wrong.
So that leaves us with a final thought, doesn't it? We've seen how these ancient systems were built around concepts like potestas, sui heritas, and mechanisms like the slave heir, all deeply tied to managing social disgrace and transferring blame. Our modern legal systems look very different on the surface. No paterfamilias with life and death power, thankfully.
But how different are the underlying preoccupations? When you look at how modern society handles, say, corporate bankruptcy or political scandals or even just public failures, how much are our modern legal and social frameworks still fundamentally driven by that ancient impulse? The impulse to avoid public shame, to manage reputational risk, perhaps even to find a legally accountable party, maybe not a slave heir, but perhaps a lower-level executive or a specific department onto whom the blame can be formally shifted.
It makes you wonder, doesn't it? Are our laws truly just about impartial justice, or are they still, perhaps, sophisticated tools primarily designed for managing that very ancient fear of social disgrace and the strategic transfer of responsibility?
Something to think about.